Good evening, everybody. Hope you are all doing well. Today is November 19th, 2025. We have, looks like about 6 more weeks before the end of the year. Hard to believe that 2025 is coming to an end, but it is. We'll see. We've not yet heard. I know one of the things in a lot of people's mind is whether Social Security has announced their long-awaited change in the rules. That has not happened yet. I'm keeping an eye on that. Obviously, I will let everybody know as soon as that happens, if it does happen. But so far, no news is good news. And hopefully the powers that be will get distracted by some other scandal or something else that will keep them from messing with the Social Security system too much. All right, so one thing I wanted to talk about a little bit before we get into the questions, something that's come up in a couple of hearings recently, and I wanted you all to be aware of it and just to be thinking about this. No big deal, but it does happen a good bit, and that is, I frequently see situations where my client has earnings after onset. So the scenario would be a person says, I became disabled May 13th of 2024. And yet the earnings record shows substantial earnings, $10,000, $15,000 earnings in the third quarter of 24, the fourth quarter of 24. And of course, the judge is going to see that and want to know what's going on. And many times the answer is the person got a severance package or there was accrued vacation pay, something like that. It could be anything, really. But typically it's something that's already been owed. Or again, severance package is very common, a buyout, something like that. My point is that if you did receive money from an employer after the onset date, be prepared to explain it. And so what's happened in a couple of cases for me is the judge, I saw it, I mentioned to my client, hey, we've got earnings after onset, asked my client to explain it. It was severance, it was this. Sometimes they're not really even sure if it was 2 or 3 years ago. But what ends up happening is the judge will say, well, I can't close the record. You need to provide me data, documentation. So I had a case recently where my client, it was a good, strong case. And I think it was, again, April or May or June that he became disabled, but there were earnings in the third and fourth quarter. And so we were able to get all the severance package documents uploaded to the judge, case approved, everything's fine. My point here is that judges are not going to just believe you. If you say, well, this is accrued vacation, or this is long-term disability, or this is a severance package, you're going to need to prove that. So, judges, not that they're looking for reasons not to believe you, but, they have to justify their decisions. And one of the things that the next level up will see is if there are earnings after onset, they will want an explanation, a clear explanation, obviously with documentation would be better. So just be aware of that. That's just something that's come up in a number of hearings. And more I'm seeing situations where people are in jobs, they get offered a buyout, they get offered a severance package to leave. And this is just something we have to deal with. So again, just be aware of it. And if that is the situation you're in, try to get that documentation together, have it ready to go so that your lawyer can submit that prior to the hearing. And of course, the other thing would be always ask your lawyer, or if you're not using a lawyer, look at the earnings record and see, are there earnings showing after the onset date? Onset date being the beginning date of your disability. That is something you will always need to address. Okay, hope that was helpful to you. Let's kind of jump into the questions. I already got a bunch of questions here. Kevin says, hello from Morristown, Tennessee, Kung Fu Grand Lawyer. I'm not sure what that means, but I guess it's a positive. Hello from, I've never heard of Morristown, Tennessee. So been to Nashville, been to Knoxville, been to Chattanooga. Not sure where Morristown is. I'm in Atlanta, so not that far away. We've been up there a number of times. Nashville in particular I really like. It's a fun place to visit. And Chattanooga, wonderful aquarium there. Wish you had, well, I appreciate that, Kevin. I will tell you that winning cases at reconsideration, very, very difficult. The percentage of approvals is pretty low, especially now with all the, now I guess the government shutdown is over. I think that we are starting to see things speed up a little bit. I know I'd gotten a couple of literally in the last week, I got 3 or 4 decisions, fortunately, all favorable. And for about 2 weeks, there was nothing. So I'm thinking that the shutdown being over maybe has loosened things up, and people that were doing other tasks are now back to their own tasks. So hopefully that's the case. Hack Assad, good evening. What does this SSA update portend? On 11/18/25, a rep in Philadelphia started a final review to make sure you still meet the non-medical requirements for SSDI, and SS rep may contact you. Good question. Here's the answer, is that there's obviously, in a disability case, an SSDI case, and an SSI case for that matter, but let's just talk about SSDI, which is where you've paid into the system and you're claiming on your own earnings record. One of the issues is obviously medical. Do you meet the medical requirements? And generally speaking, if they're telling you they're looking at non-medical, means you've already met the medical, positive sign. The non-medical would be, getting back to what I was just talking about, are there earnings? Is there evidence that you're continuing to work? Is there some other evidence that suggests that you are engaged in substantial gainful activity? You're volunteering someplace. That would be the non-medical things they're looking at. Is, are you doing something that would suggest you're not disabled? In an SSI case, I'm going to move this down so I can, okay, because I'm looking at both the vertical and the horizontal feed, so that's why I'm moving it down there, because in the vertical feed, it's above my head, the question. In an SSI case, a little different story, because SSI has an income and resource limit. So again, this is the same sort of thing. They want to confirm nothing has changed in terms of your asset picture in an SSI case. SSDI, it's really only going to be about earnings or SGA. So that's what they're looking at. So usually if they're looking at that non-medical, that normally they wouldn't do that if they hadn't already made a decision that you meet the medical requirements. So my guess is you're probably getting pretty close to a written approval. So hopefully that will be the case. Autumn Harvest Dude Ranch, this is Karen, one of my clients. Hello, Karen. How are you doing? Thank you for all your help. Absolutely. We are glad to help and good to see you here. RD, hello from California. Hello, RD. Corinder Mali, hello, buddy. Hello, Corinder. Hope you are doing fine. Let's say Cynthia. Hi, Cynthia. I think I already said hello to you in the comments before. Good to see you here. Corinder says, I'd love to join you some point. Not sure what you mean, but certainly I'm glad you tuned in. I appreciate that very much. Christy, hello, Christy. How are you doing? Please describe, says Christy, what goes on at a hearing when it's just a medical expert. So I'm going to make some assumptions here, Christy, that when you say just a medical expert, that it might be a second hearing. Well, let's go through the whole process, just so you kind of know. Most hearings, disability hearings before a judge, there will be 5 people in the virtual hearing room. You have the judge, you have the claimant, you have the attorney, you have a hearing reporter who's operating recording equipment, and you have the vocational witness. Those are the 5 people. In a small percentage of cases, and I'm going to go out on a limb and say less than 10% in my experience, and maybe more in others, my experience, less than 10%, there will be a medical expert. This would be a person who has knowledge about or is able to help the judge kind of understand a somewhat complicated medical record. That's what the medical expert's there to do. And usually, it used to be there was like doctors on a panel. Now it seems like there are services that provide doctors to perform this function. And a lot of these doctors are either retired doctors, or they are, let's say if it's an orthopedic surgeon who's no longer operating, semi-retired, or sometimes it's younger doctors trying to make a little extra money. But they're there to really review the medical record and to offer commentary about what it means vocationally. But it's purely based on the medical record. And in my opinion, many of the medical experts that I've seen lately, and again, very tiny percentage of cases have them, the medical experts kind of overstep their bounds in making vocational assessments. I don't think that a medical doctor looking at a record can drawing any conclusions about how long you can sit, stand, walk, lift, carry, things like that, but they do. And sometimes it's based on what they saw on the record. Other times it's based on their quote unquote expertise. And I've pushed back on that, by the way. If that's the situation, I'll cross-examine the medical expert, or, really hone in on how they arrived at that conclusion. And a lot of times it's just sort of this very general, well, based on an MRI that shows a moderate disc herniation, I'm assuming the person could lift 20 pounds. Well, that's a pretty big assumption. So my question would always be, isn't it possible that a person with this level of herniation might be limited to lifting 2 pounds or 5 pounds? Well, yes, it's possible, but not likely that it's possible. But you don't know because you never examined this claimant. Correct. So that's sort of the way you deal with that. So anyway, the medical experts are there to help the judge. Some judges will call them if the record is very, very complex. It's thousands of pages, and medical expert will kind of go through and point out the most important things, which I do in a brief anyway, but medical expert will do that. That's fairly uncommon, but it does happen. The other time you see a medical expert, I'm going to go to Christy's question, the only person there would be the medical expert. That's typically in a second hearing. So it might be a situation, I've had a couple this year, where judge takes testimony, the medical record is not exactly clear. I mean, there may be some, nothing recent in terms of an MRI, or there may be a conflict in the record, something like that. The judge will ask a medical expert to come and testify at a second hearing, or the judge may send out medical interrogatories, questions to a medical expert or one of these services to get more clarification on the medical issue. And in those cases, generally the claimant is not going to testify again. The judge already has the testimony. Now, logically, if the first hearing was 4 months ago, I think it's pretty unlikely the judge is going to remember what happened. I also think it's unlikely the judge is going to listen to that audio recording to bring him or herself up to speed. That being said, the medical expert will again testify about what he or she thinks the medical record says about the severity of the medical condition or the vocational implications of a medical condition. And again, subject to the same cross-examination. The issue that we run into is that Social Security law says that a judge can rely on either written reports, consultative reports, non-examining doctor reports, medical expert testimony. The judge can choose whatever medical source he or she wants to, rely on that to justify a decision. And it's, as long as it's reasonable, it's not going to be overturned on appeal. I get the sense that most of the time, if a judge is calling a medical expert, because it does cost the agency money, I think that the judge is trying to do the right thing. The judge wants to make a good decision, an equitable decision. Not always, but I think they're not going to do it unless there's a reason for it. So, I think that there are some limits as to what the medical expert can do. I know if I was a judge, I would probably ask the medical expert to limit his or her testimony to clarifying the record, if there's something specific to clarify that. I have a bit of a problem when non-examining doctors start offering testimony about, reliability and needing to take unscheduled breaks and lifting and carrying and, stooping and climbing stairs, things like that. But, the system allows judges to consider that, even though, again, I think it's less valuable than a doctor who's actually seen you and knows you. But that's when it's just the medical expert. Usually it's a second hearing where the judge calls it because something in the record was unclear, or the judge felt like there was not enough evidence to support an approval or a denial, because the record has to be based on something, substantial evidence. And so there needs to be something there. And although some judges can say, well, the absence of evidence is the absence of a problem, I think that if there's enough evidence to suggest there is a problem, they just need to firm up why they're going to deny, why they're going to approve. Delphina Quintero. Hello, Delphina. How are you doing? Roy. Hello, Jonathan. Is it possible for an autistic person to apply for SSDI and work part-time in his former full job? And does autistic person level 2 with an IQ of 60 have a good approval rate? You can work part-time. Roy, but you have to keep your earnings below SGA, which in 2025 is, I think it's six. Make sure I'm not telling you wrong. I think it's 1620. Let's just take a look just to make sure, because I want to make sure I'm right. Yes, 1620 for 2025. It will be $1,690 gross income in 2026. So the point here is, if you're working and your earnings, your gross earnings, that's before taxes, in a calendar month is below $1,620, 2025, working will not disqualify you. That level of earnings is considered less than SGA, less than substantial gainful activity. Now, a judge could look at it and say, your earnings are every month $1,619. That looks a little suspicious. So a judge might find that less credible. But you can certainly work part-time, and if your earnings are $1,500, $1,400 a month gross, I think you'd be okay. A couple of comments about that. One would be, if you're paid biweekly, remember that 3 times a year you get 3 paychecks. That's going to take you over that 1620. So let's say that you're getting $800 a week. Then or I'm sorry, $800 every pay period. Well, if it's 2 pay periods, $1,600, right? If it's 3, $2,400. So you got to be careful about that, and sometimes that can be hard to take a period of time off so you don't reach that. I think the second thing is just that $1,620 is not a lot of money. $1,690 is not a lot of money. It's like $20,000 a year, so it's not a ton of money. But you just that's what they do allow you to work. All right. As far as the I'm not sure what level 2 means, but a low IQ, that's going to obviously limit you to unskilled work. And I think that the question here is, can you make the argument that the part-time work you're doing is the most you could possibly do, and that maybe you're getting special considerations? At work, your boss or supervisor is allowing you more leeway to work more slowly, or to come in late or leave early. So if there are any special considerations, that would be something to bring up. But anybody with an IQ of 60, again, keep in mind, IQ tests are not the end all of end all. It's a measure of intelligence, but not the only measure of intelligence. I think again, it's going to limit you to unskilled work. It's going to make it difficult to transition into something else you don't know. But at the end of the day, that alone is not going to, I can look at the listing. Let's just take a look at the listings. I know there's a listing that does talk about IQ level. And let's see here. I think it's called intellectual disorder. Okay. So a 1205, the listing of 1205 is significantly sub-average general intellectual functioning, depth in adaptive functioning, and disorder is like basically been around for a long time, an IQ of 70 or below. So yeah, I think that being at 60 is going to really move the meter quite a bit for you, assuming that there are symptoms. Obviously, autism has its own symptoms, and sometimes IQ tests don't measure intelligence in an autistic person because of issues that person might have taking the test. But certainly, if that is the true measure of intelligence, that's low enough where you're kind of at that listing level. And if your other functioning suffers, and if the work you're doing, you're getting some sort of special consideration, some sort of a accommodation, that would go a long way in your favor. So I think, all in all, I think your argument's probably pretty good, assuming you've got specific things that you would have trouble doing. And again, in my experience, what they look at is, you're able to work. That's great. And I think that's a credit to you. What enabled you to work at this job? Was it because you knew somebody, or your family knew somebody to put you there? Were you getting, again, special considerations? I think those are questions that a judge would ask. But that those are the things you cited are putting you more than halfway there, in my opinion. Rodney, one of our old clients. Rodney, how are you doing? Good to see you. Gojo, good evening, Gojo. Delphina says hello again, Delphina. Bala 2001, one of our regulars, good evening. Kelly Bricker. My husband got a message regarding his appeal, the last line of which is, on November 13th, a Portland representative started a final review, make sure he made the non-medical. All right, this is going back to that same question that I believe a gentleman named Haq Assad asked earlier, and that is that usually if they're looking at it for non-medical compliance, that means that you've met the medical, because Social Security doesn't waste time doing part 2 if part 1 isn't met, if that makes any sense. So they probably have decided he meets the medical. Now they want to confirm there's no earnings. There's nothing to suggest that it's changed, that he doesn't have any substantial gainful activity. So you're more than halfway there, is what my point is. I think it's a pretty good sign. 425 Sports, good evening. Good evening to you. Okay. Jonathan, good news. MBC Ducci. Okay. Washington Post just broke saying they're not going to go forward with Social Security disability rule changes. Okay, that's great. I will definitely take a look at that. I actually have a subscription to the Washington Post because I know there's a woman named Lisa Ryan, Rein, who does a lot of reporting about Social Security, and it's really very useful. And so I, subscribe basically for that. I think it's also, I subscribe to the Wall Street Journal, the Washington Post, the Atlanta newspaper. I subscribe to a lot of different publications just because you don't know what to believe out there. So I like to get it from all different angles just so I can sort of see, but that's great. I'm just looking real quick here. Let me just see if there's anything I can find. And let's just see, I'm going to check under Social Security. I'm just looking at let's see. Social Security scraps plans to limit disability benefits after uproar. Okay. That Lisa Ryan. Okay, so let me just share the screen here. That's very good news for everybody here. And thank you, MBC Ducci, for letting us see that. Okay, so here's the article from the Washington Post. It came out at 6:45 p.m. today, so it's very recent, and I haven't read it obviously, but they are going to scrap the plan. A lot of bad feedback there, and it's interesting here. One of the things it says, and again, I'm going to read the article, and I'll probably blog about it or something like that later. But one of the things they says here is the agency is halting a plan to use modern labor market data to help judge whether disability claimants can work. A project that has cost the government $350 million so far. The new data will replace the old data that's outdated. Here's what's going on behind the scenes. They have no idea how many jobs exist for any particular occupation. The scale, the scope of a project to make that determination, I think is, overwhelming. And I suspect that, the lawyers at Social Security told the executive branch that if you make these significant changes, what's going to happen is, every lawyer who does this is going to challenge unfavorable decisions on the grounds that they're using inaccurate and outdated labor market statistics. In my opinion, and this is just me, I think that the courts have given Social Security something of a pass in using, outdated data because, the rules are, at least somewhat helpful to people who are over age 50. I think that the signal was the courts aren't going to do that if you start screwing around with the eligibility. So bottom line is I think this is, for disability claimants, this is very good news. Doesn't mean it won't come back at some point, but I think that for right now we're pretty safe. So that's NBC. Thank you very much for pointing that out. I'm glad I was able to find it very quick. That's great. Okay. Okay. Emiliano Guzman. When you sign up for virtual mental health meeting with Social Security, what questions they ask? What's the purpose? All right. So what you're asking, I believe, is about a consultative evaluation. It's not a virtual. And they can be virtual. And basically, what that means is that Social Security will send you to a psychologist or a mental health professional on their panel, and this would be to do an assessment of your mental health status, whether it's depression, anxiety, bipolar, um, whatever the issues may be. And so their psychologist will run through a battery of tests to determine, A, are you being truthful? Are you malingering or anything like that? There's certain questions they ask. Then they do a general intelligence test. Then they assess, your how you might deal with stress, how you might deal with complex job instructions, simple job instructions. There's a lot of questions, and quite frankly, I don't want to. I mean, I've read enough of these reports. I could probably give a list of the questions. I don't really want to do that because I think if you know the questions, you're not going to be able to get the conclusion that the doctor will draw won't be accurate and probably not in your favor. But if you think about it, if you know all the questions, you'll be prepared for them. And if you answer them truthfully because they're coming, then you will the report will suggest a greater than real capability. If you try to fake it and say, I don't remember the secret, how to count backward. I'll give you one of them. They'll say count backwards by sevens from 100, 193, 86, or whatever it will be, and 79. I hope I'm doing that right. I don't want to take one of these tests myself. But anyway, that's one of the questions. Well, if you know that's coming, okay, you can have it all in your head. Okay, I know the answer to this. So then when the report's done, that's going to be factored in that you had that capacity. And so your ability for complex reasoning may be graded at a higher level than it really is. So I'm not going to tell you the questions, but I think it's just going to be a series of questions that they ask you. They'll ask you about your background. I will tell you that. They'll ask you about why you're filing for disability, any history of mental health trauma, physical, emotional, sexual abuse, what if there's any particular trigger to the current mental health issues, how you interact with people, things like that. So it's just usually I think it's an hour to 2 hours, depending on how in depth they go, just to get an assessment of your level of functioning mental health wise. And again, keep in mind that everything in Social Security is about your capacity to be a reliable employee. So it's all about your vocational capacity. So the questions they're going to be asking, that what they're trying to find out would be, could you get through a work day, and could you perform the work? Would you be emotionally stable? Would you be able to, organize yourself, things like that? And that's what they're trying to find out. And there are going to be a lot of questions to hopefully get them to that place. So that is what the mental health consultative will be. My experience, I will tell you, is that mental health consultatives usually will not hurt you. They may be neutral or they may help you. The reason for that is that the doctors that Social Security uses for these evaluations generally are actively practicing psychologists, and they are seeing real people with real problems every day. By contrast, in a physical consultative, the doctors typically are working at facilities that exist solely for doing testing. And so they don't see real patients, and they're biased because they're getting mostly paid by insurance companies to minimize, the severity of a problem. Their bias is to minimize the problem. So with some exceptions, and we had we had a medical expert, I'm drawing a blank on his name, but he was in the live stream. John Foster, Dr. John Foster, if you look him up in the YouTube channel, but he came on and he described what he did physically, and he does. I think he does. The way he described it was he does a very comprehensive review. He does not have an axe to grind. He's not trying to get people denied. He's just basically there to hopefully give them, do a fair assessment. And he talked about the limitations of what he could do given the time limits. that he's in, but he's the exception. Most of the time, I always tell, the shorthand I use is that many people are sent to these industrial clinic doctors. And, my perspective is, I've done insurance, I've done some, liability work over the years. My wife does Georgia workers' compensation, and insurance companies will use these industrial clinics because they sort of have control over what comes out in terms of the reporting. If you're in a big insurance company that writes a lot of workers' comp in a state, let's say like Georgia, we have to have here, and most states will have something similar, a posted panel of doctors. So if you get hurt, you can look in this panel, and you have 6 choices. You can go to any one of these 6 doctors. Well, they like to put these industrial clinics on there because, if let's say you're an insurance company and you write, 15 or 20,000 businesses in the state, you can work out a deal where these industrial clinics, and many of them have multiple locations, will, provide medical services for workers' compensation. Obviously, though, the bias is going to be you just signed a contract for $15 million with some insurance company. You're going to want to tell them what they want to hear. And these are the same doctors that many times do the Social Security medical, physical consultative exams. There's nothing equivalent to that in the mental health realm. So mental health typically are real doctors treating real patients. So I think my experience has been that you usually get a fairly fair shake in a mental health consultative, not always so much in a physical consultative. And judges know this. I mean, I kind of wonder sometimes. I mean, I know that Social Security will send people out at the administrative level, the initial recon, they'll send you out for a physical consultative, and they know what's going to come back. They use it as a basis to deny. You get in front of a judge, a reasonable judge, they just ignore it. I mean, it's just pretty useless. And, it's pretty easy to get past it. Of course, there are some judges who will use it to deny, but most judges know it's pretty much garbage. All right, Corinder says he's got a disability community. Absolutely happy to chat with you about that. Always looking for, places, resources to spread the news and to collaborate with. So absolutely reach out. Hack aside, is possible to request the documents used in adjudication of your claim? Yeah, it's a good question. I believe that you can contact your local office and ask for it. I know the way I get it is we have something called Electronic Records Express access. And so as of really about a couple of years ago, when I file a new claim, I usually get access to a file, my client's file, within about a month, sometimes less, but 2 to 6 weeks, let's just say. So I can see everything that's there and I can download it. And a lot of times my clients want to see it, I'll just download it and send it to them. I think that you can go to your local office, make an appointment if you can get in, and ask them to put it up, burn a CD with all that on there, or to at least look at it. So it's not that they're hiding it. It's just that the practical matter of getting it from their file to your hands can be difficult, because I don't know that they're going to take the time to email it to you. Realize at the initial and recon level, the documents in the file, imagine a big file folder, with, just a big, thick mass of papers stuck in it. Why do I have a big mass of papers here? Different question. But, it's not organized really very well. Once the hearing is scheduled, Social Security hearing office goes through, numbers all the exhibits. So it's much easier to work with. But, if you want the unedited, kind of raw version of it, you should be able to get that. But getting to an office, getting them to make a copy for you may be easier said than done. If you have an attorney, it's all electronic, pretty easy to get. Jada Nicole, had my hearing, the judge asked the vocational witness 2 questions. The first was 3 jobs. The second was longer, no jobs. End of the hearing, is this good or bad? Jada, I hate to do this to you. I'm going to have to answer it depends, because the judge will use one of those questions as the basis of his or her decision. The first question, sometimes judges will offer the first question that really reflects a very minimal level of impairment, basically what the state agency already found. Not sure why I have some ideas as to why they do that, but it's kind of a waste of time. And then some judges, the second question, they'll throw in a consideration that always results in no jobs, such as the person would be off task 15% of the day or more, or the person would miss 2 or more days of work per month. That will always yield a result from a vocational witness. There are no jobs. So it depends on the judge. Some judges will start with a very mild impairment question. The second question reflects the reality of the case, and it's really what they're thinking. Other judges will start with the question of what they're really thinking. The second question will be the throwaway, so they can say, well, we considered if the person would be off task 15%, but we don't think that's the case here. It really depends. I can't tell you. I mean, I would say one clue would be look at the approval rate of the judge. Go to one of these websites where you can look at the approval rate. I think I'll put those in the. I'll put one in the description here. This is one of the ones I use a good bit. I'll just stick it in the comments here. Did that go through here? Yeah, there we go. Okay. And if the judge has a 50% or higher approval rate, there's a good chance that the second question is the one the judge will use. If the judge has a 25% approval rate, more likely the first one will be. But you never know. I won a case this past week with a judge, 33% approval rate, very, very low. Good case, but I was expecting the judge was going to find a reason not to approve my client, but we got approved, so that's good. But Jade, I wish I could give you a better answer than that. It just does depend. Paul Harrison, I'm on SSDI. My notice of award says my CDR is 5 to 7 years from date of approval, and they move up the date of the CDR. That's a very good question. I know that if I had to guess, I would say that they can send out the short form to anybody at any time. I mean, realize the purpose of a CDR is to identify people whose medical condition is improved, that they could go back to work. The 5 to 7 year recommended basically is saying to you, to the world, that the idea that the likelihood that you're going to improve is pretty slim. If it's a 1 year recommended review, they think you're going to improve. It's a 3 year, possibly, but we don't know. 5 to 7 years, probably not. In fact, if you try to get your student loans discharged for disability, they're going to want to see evidence that's a 5 to 7 year review cycle, because the sign there is that it's probably going to not improve. That all being said, remember the goal of a CDR, and that is to identify people who've improved. So I look at the 5 to 7 years as sort of a minimum standard. I don't think I don't think you could object to a CDR earlier on the grounds that my decision said it should be 5 to 7 years. If it comes in 4 years, I just think that's sort of the that's a suggestion that or implication that you probably won't improve, but I don't think that guarantees you anything. On the other hand, people with a 5 to 7 year review, the presumption is they probably won't improve. Social Security has limited resources. They're going to really spend a lot of time trying to find a 5 to 7 year review person and look for reasons to terminate them when it's probably pretty certain that the underlying medical condition is pretty severe. So what I'm getting at, big picture, is if you're in a 5 to 7 year review, A, it sounds like you probably have something fairly significant. B, you may not be reviewed. It's more likely than not you won't be reviewed in 5 to 7 years. You probably may not be reviewed at all. But C, is it possible they could review you earlier? I think yes, it's possible. So, but I think not likely. I think generally you're in a better position. You're in a better position than others with a shorter review period. Alan Hurd, I turned 62 in February. Early happy birthday. we have your case. Okay, our case submitted early March. I'm in Georgia. If I file earlier start, case submitted denied. Okay, Alan, that's a great question. So what Alan is asking is that we filed an application for disability benefits. At age 60 or 61, I'm not going to talk about your particular case for obvious reasons, but in general, you file a case before 62, you then apply for disability, or you apply for disability, then you apply for early retirement at 62, and you eventually lose your disability case. At that point, you are stuck with the early retirement amount. If you win, then they boost it up to full retirement. So, it is a risk to take early retirement, but on the other hand, it's also a risk not to have money to buy food. I see a very high percentage of cases approved for people over 55 and even more so over 60. I don't take cases unless I think I got a really good shot at winning them. So again, no guarantees, but you know, I'd say if you need the money, go for it. I think the risk is not huge. It's there, but you certainly would get your early retirement. The question is, would you get stuck at the lower figure if you go through a hearing and you lose? Yes, you would get stuck. I don't think you lose. So that's how I would answer that question. But you're the one with the risk tolerance. You've got to make a decision about the risk tolerance. All right, Corinder says, love you on my show. Okay, well, you know what? Reach out to me by email and let's talk about what you would like to talk about. I'm always looking for interesting guests. I've had a number of guests. I've had other attorneys. I had a psychiatrist on who is a former disability representative. I've had consultative doctors on. I've had adjudicators on. So always looking for interesting guests. So please email me and we can talk about it. Jennifer, hey, Jennifer, how are you doing? Earnings after onset when my employer just paid my salary, even though I'm out of work. Officially, I'll go through my, so I had to prove that, or we just need to know. Okay, what I would do there, Jennifer, is we would get a statement from the employer, basically either showing your file, showing the dates of attendance. We could get a statement from a former coworker who could verify that you did not appear at the job site after a certain date. Your testimony would also be evidence of that. That's how I would deal with that. I mean, ideally, the employer would give you a statement that says that Jennifer was an employee here because of her years of loyal service. I paid her, 3 months of salary, but her last physical day of attendance was, your onset date, and that's how I would deal with it. It's something to get past. But I certainly I would need to know that, but I would want to get past it because, it's going to show earnings after onset, and we would want to catch that and be proactive and deal with that. Hakasad, is severance paid or unemployment considered work or income, not for Social Security purposes? So what they're looking at is earnings for work performed. So if you stop working May 23rd of 2024, you get severance pay in July. You haven't worked after May 23rd of 2024. So any money you got after that is really passive income. Unemployment, same thing. You're not working for that. This is a benefit. People will sometimes ask me, does collecting unemployment disqualify me from Social Security disability? And the answer is no. Unemployment, you're basically stating, I'm ready, willing, and able to try to work. You're not a doctor. You can't say you're asserting that you're available to work, but I say you're saying you're willing to try to work. At one point, 20 years ago, there were a few judges who would, take the position if you're getting unemployment, you're basically asserting you're ready, willing, and able to work. That is not consistent with disability. That argument got shut down. I suspect on appeal. I mean, I made the argument that, if you're going to accept my client's assertion that he's able to work as of this date, then you need to accept his assertion he wasn't able to work on that day. And so since he's not a doctor, you can't accept one without the other, and that kind of shuts that argument down. I don't think that unemployment is an issue anymore. Especially during the COVID time, people were getting unemployment because they needed to eat, and judges were very aware of it. So, but the answer to your question is severance, unemployment is not considered income for Social Security purposes, it's not SGA, substantial gainful activity. Blu-ray, are CDR slowing down in the Trump administration? I have not seen statistics to that effect. I know that, they were slowed down really towards the middle part of 2024. The commissioner under the last commissioner under Biden was Martin O'Malley, who I think was a very good commissioner. And he basically said, we have such a problem at the front end that we're going to take people off the CDRs because statistically they weren't generating a lot of money. And we're going to put them at the front end to try to reduce the backlog. And then you had the government shutdown. Then you had people resigning and not wanting to go back to work. They've had personnel issues, is what I'm getting at. So I don't think it's for lack of desire to cull the roles. I think it's just from lack of personnel. So I'm going to say, generally speaking, yes, there has been from what I can observe, it's not been aggressively pushed. Every once in a while, you'll see under Democrat or Republican, you'll see a real push, and it's usually coming from Congress to push Social Security to really increase those CDRs. Haven't seen that lately. So now, this article we just saw that they've kind of scrapped the plans to change the rules. Maybe the quid pro quo is that we're going to start seeing a lot more CDRs. Time will tell. I don't know, but right now it doesn't seem like they're as common as they were in various times in the past. That's my take. Chan Tet says, hello, Chan Tet. Glad to see you. Corinder says, on camera to talk to you about our Social Security law for disability, community law, and judge for disability. Okay, again, Corinder, please feel free to email me, contact me. We can talk about, whether there's a good nexus there for what you do and what I do. Happy to hear you out, though. Essay applied May of 25, received a $10,000 separation incentive from my employer. In August of 25, we'll receive another $5K. In August of 26, with separation incentive written in the check. Probably, yeah. I mean, I think that judges, are probably going to just look for some evidence. So that's probably sufficient. I might want to have a little bit more. I would think that there is something in writing about that separation incentive. So I would tell you to get that. That would be better, I think, than just relying on what's on the check. This is water, by the way. Some people say, you're drinking a beer in your live stream. No, don't like beer. Just don't like it. But I would not be drinking beer in a live stream. In answer, yeah, can you provide evidence of severance packages to the adjudicator? Sure. I think, though, especially at the adjudication level, you'd want to see something a little more formal documentation-wise. How can deaf, Corinder says, or hard of hearing individuals best access Social Security services and legal support? I believe that, well, a lot of the things are done in writing, so that would not necessarily require, a person's ability to hear. At the hearing level, they do provide hearing, impaired services for people at hearing levels, whether it's person who can sign or I think that's what they do. I think over the years, I've only had one hearing impaired. I've had a couple. I should back up. I've had a couple there, and when the hearings were, and that may be a situation where you'd have a live hearing where you would have actually an interpreter there, and there may be lawyers who do this that are sign proficient. I don't know. I'm not, unfortunately. So when I've done these, you have a person who can use sign language and they interpret, just like you have somebody interpreting another language. But Social Security does provide that service. Yes, absolutely. And now, by the way, getting back to Corinder's question here, there are these apps now, and I've been kind of exploring some of them that will generate transcripts in real time. So In fact, if you notice in my videos, I use a program now that will um, create a written transcript, and I'm kind of attaching that to all the videos. I use one called Descript, Descript. There's other ones out there. Um, but that technology is getting so much better where, you could, if you're hearing impaired, the judge could be talking, your attorney could be talking, and you can see that on the screen in front of you in real time. You don't really even need an interpreter necessarily, or maybe that would be a backup to an interpreter. So I think those technologies are going to make it, a lot easier for a person hearing impaired to pursue disability. On the other hand, what the law giveth, the law taketh away. That technology also may make it easier for a person who's hearing impaired to work, because even if you're hearing impaired, you might be able to keep a job because of the technology that allows you to function in an otherwise hearing workspace. So there's that. So that's just like I said, sometimes they give you and sometimes they take it away. Ba, 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 ba. Okay. Jonathan, you filed my application to the shutdown, so you waited to file by paper. Jen told me the government opened we get an electronic copy. We don't, we talk about filing by paper. We don't generally file, it's usually filed electronically. There are some cases where we cannot get the electronic system to work. We have to file it by paper. If I'm hearing what you're asking me, there are some cases that were filed on paper because the system would not take it. And this is a tiny percentage of cases, but sometimes the system will not take electronic application. Usually, not always, but usually, Social Security will transfer or transition that case into an electronic folder. I have had a number of cases, though, where they did not. I had a case probably as recently as 2 years ago where it was a paper file. And you physically had to, I physically had to do a hearing in person because it was a paper file. I think that's pretty rare nowadays, but I think that generally speaking, cases that were filed on paper for whatever reason have been moved into the electronic format. So we should be able to get that. That would be something to ask Jen if it has been moved into it, and if not, when are they going to move it? Because they need to. Let's see. Hakasad says every indication pointed to approval. Just checked the portal and said denial. What could be the possible cause? At the initial and recon level, they're generally looking for a listing level impairment, or it could be a grid rule thing. Now, I think you had asked me earlier whether a non-medical review, what that meant. And my response was that I don't normally see non-medical reviews in cases where they're going to deny you, because why would they waste the time doing it? Maybe I'm incorrect. Maybe at the state agency level, they are doing the non-medical reviews regardless, just to complete the file. Or maybe there was something in that non-medical review that suggested that you're still working, that there's earnings after onset. That could be the reason for the denial. What I would tell you is, when the written notice of denial comes out, look at it carefully. What was the reason? Was it because of medical issues? Was it because of earnings after onset, or some other non-medical reason? Or you don't have enough credits for disability. That would be another reason for it. Or if it's an SSI case, you have household assets, so it would take you out of the SSI qualification. So look carefully at why they would have denied you. What's the reason? All right, Christy had asked about the medical expert. And my response was, she said, when would they have a medical expert? And that's the only person who testified. My response was that medical experts sometimes get called by a judge to, review the record at a second hearing. And Christy said, yes, makes sense, because the judge request this the first time through the process. So maybe at the hearing, the judge says, we need to have a second hearing with a medical expert there. Doug S. says, I was recently hospitalized due to life-threatening infection, a complication of lymphedema. Lymphedema is a swelling throughout the body. I had to have my left leg amputated above the knee, and now in a wheelchair. I'm a candidate for SSI disability. Well, to answer your question, you are, as far as disability, absolutely. In fact, if I'm not mistaken, an amputation might be a listing level impairment. Let's take a look at listing 1. And let's see what it says here, because that's the musculoskeletal one. And listing 1 says amputation due to any cause of both upper extremities, of one upper extremity at or above the wrist, and one lower extremity, amputation of one or both lower extremities at or above the ankle. With complications that are expected to last 12 months. So let me just share this with you very quickly. So Doug, I would look at, I've got a website called meetalisting.com. You can go there, and that will give you a link to the actual listings. And if you look at listing 1.20 right here, it says 1.20D, amputation of one or both lower extremities, and you've got your left leg would be one of your lower extremities occurring at or above the ankle. You had it above the knee, with complications that have lasted or expected to last a continuous period of 12 months. So complications could be pain, could be infection, could be inability to adjust to a prosthetic, anything like that. But it looks to me like you're at listing level. So answer your question is for disability, I think you've got a very, very solid chance. Now, you said SSI. I'm not sure if you mean Social Security disability or SSI disability. SSI is a means tested program, and that means that you only qualify for SSI if you are at a very, very low household income, very, very low, really poverty level, and you have no assets. So I think that would be a reason why you might, that's why you get SSI. If you have assets, somebody in your household works, then you wouldn't qualify for SSI. A lot of people use the short as SSI, they mean disability. But if you really mean SSI, there's a whole non-medical component to it. But disability-wise, you do, I think, have a really strong chance. Time frame. Generally speaking, cases I'm filing now were filed. I'm trying cases that were filed 2 to 2.5 years ago. That's kind of the time frame generally from start to finish, 2.5 years. If it's longer than that, there's something's going on. There's a red flag there. And I think SA is asking about the evidence of a severance package. Yes, it can be provided at the local office. Madeline from my office. How are you doing, Madeline? I hope you're doing well. Hope things in Oklahoma are good. Good to see you here tonight. Check stub. This is again about the severance package. I think a formal, severance paperwork would be better than a check stub. Okay. No, that was a strange sound from my phone. Sometimes you get these strange beeps and buzzes, and I don't know where they come from, but I think I know where that one came from. But yeah, it's kind of strange. All right, JRP 1010. After your hearing, can you still provide medical records? Attorney said the medical part was closed. Hearing was over with. Yeah, generally speaking, the record closes. Technically, it closes 5 business days before the hearing. So it's usually 7 or 8 calendar days. And, unless you provide a letter saying we want the record to be left open because we're trying to get this, you can't submit anything afterwards. I'd say most judges are going to be pretty inclined not to give it any look. Every once in a while, if you have some really unique circumstance, you went to the hospital, and they've been struggling to find a diagnosis, and a week after the hearing went to the hospital and a specialist figured out what the problem was, that would be relevant, I think, to ask the judge to consider that. What I would probably do in a case like that would be to say we need another hearing because we've got some new evidence that is so new, so significant that we need to have another hearing. But generally speaking, you cannot provide medical evidence after the record is closed or after the hearing, certainly. Yes, 1620 SGA for 2025 is 1620. Let's see here. Zippy is near 61. Onset date 2019, started collecting SSDI in 2022. My ward 5 to 7 years. What are the chances? Slim and none. They're not going after 61-year-old people. They want people that are 35. They're not trying to, people that have they're all getting close to full retirement. It's not worth the effort, really. So I think that's pretty low. Kelly says, have to veer away. Okay, I understand very much. And glad you came. All right, I'm going to go ahead and I'm sending this to Instagram. And what's happening is Instagram, after an hour, will basically disconnect. So I'm going to go ahead and reconnect it. So if you give me 1 second here, let's do it. Not sure who's watching on Instagram, but let's try and see what happens. This will just take, I'm getting better at this. I'm getting better at this. I do have an Instagram, Ginsberg Law Offices. All right, let's see if we can. Stream key. Yeah, sometimes I think about this and it's like, this is like science fiction. I'm streaming a live video. There we're back on Instagram. Gotta go live here. I'm streaming a live video to Instagram all over the world from my home office. It's really pretty crazy, but all right, we're back on Instagram. So those of you on Instagram, I'm here. Let's see if we can go. There we go. We're back on. Okay. Sean Forsman, I got the same mess that a non-medical review is being done. The next day got notice of denial. All right. So I think what I've learned here is that my assumption that doing a non-medical review, meant that the medical review was in your favor is probably incorrect. So I'm going to try to find out more about that. Again, it could be the denial is based on the non-medical review, but I'm getting the sense that that may not be the case. It's possible that a state agency, they ask them to do the non-medical review just to make the file complete. Although it just doesn't make a lot of sense to me, because in other areas, I'll give you an example. I look at all the state agency denials, and sometimes they will, look at the person's past work and say, we're not going to evaluate this because there's no need to, because it doesn't matter. The person is limited to a light RFC, and the past work, there's plenty of jobs they could do at a light RFC, and their past work was a light job. So, they don't even bother. But so it seems odd to me they would spend time on something if there was another reason to deny it. But maybe there are two processes going on at the same time. I don't know. Maybe there's somebody at the adjudication office is looking at the non-medical part, i.e., whether there's earnings after onset, and another person, the adjudicator is actually looking at the medical. But I'm going to find out. We've got a couple people that, one that was at the time when she appeared, Linda. If you look back on my conversation with Linda, I will ask her. She's no longer with the agency, but she would have answered this. I will ask her. Her name is not Linda, but I'll ask her. That was what she used. Maybe get her back on now that she's not there anymore. Okay. So again, Sean got the same mess before. Let's see here. Yep. Okay. So again, I've said I know, we don't want to talk about individual cases online here, but yeah, I think that same thing happened to you. So I'm thinking that my assumption was wrong, and I will find out an answer to that. I think that we need to, I need to talk to Linda, the person who is the former adjudicator, and just ask her. So I've had a number of people tell me that they get a notice it's a non-medical review. We're assuming they're going to get approved, and then they get denied. And can there be an explanation for that? So if anybody knows, speak up. But I'm going to find out from the adjudicator, the horse's mouth, as it were. Okay. SA says the portal of my case has been assigned to a disability determination examiner, and is the address. So yes, the case is now at being adjudicated. Before it's adjudicated, it goes to a staging where basically it's sort of in limbo, waiting for room, waiting for capacity at the adjudication office. Very frustrating. Like in Texas, that can be a year. It could be 15 months. Florida can be a long, long time. So now at least it's moving. Things are moving. Pretty hard to see my screen or chat tonight. I'm not sure why. If you're looking, it looks like you're looking at it on a phone. All right, and I'm looking because I'm looking, by the way, I've sent at my screen, which shows the vertical look, and the text is pretty small. I'll grant you that. And what we're talking about is that the program I use, which is called StreamYard to stream, and this basically it's a web-based program. It has capacity to offer streaming services both for vertical, like you'd see in a YouTube short or Instagram or TikTok, and horizontal, which is what you'd see in a laptop. And so if you're looking at it on a phone, it automatically formats it for the horizontal. What Afsano is saying is that it's really small because you're looking at it on a phone. And so the question is it possible to make the type size bigger? Like certainly for the questions, I don't know. This is a brand new feature of StreamYard as of 2 weeks ago. So I can ask them, is it possible to make the part here where it's, it says, it's pretty hard to see the comment there. Can I make that any bigger? So I don't know if I can. I try to read those out anyway, by the way, but that's why, because you're looking at it. I can tell one of the things it does show me is you're looking at this on a telephone, as is Kelly. Okay. Exactly the 6-month mark. Okay, so you're still, assume it could take up to 12 months, but you get to 7 or 8 months, it might be worthwhile contacting your congressperson. Yeah, I agree with Kelly. Sean's experience, as well as other folks who've mentioned this, of Senna and the other gentleman who's I'm drawing a blank on his name, but Haq Assad said the same thing. Yeah, these we're all kind of learning together. I think that, again, I thought that there was a logical connection between non-medical and that they've already decided the medical, but that's not the case. So I'm going to find out more about it. Jackie H. Been almost a year. Yes, it has. Ground News is a great subscription. Okay. Never heard of it. Ground News. Let me plug that in. Ground News. Okay. All right. I've never heard of it, but yeah, well, actually what I do for what everybody's worth is I use a little program called, I think it's called ProtoPage here. Let's see what it is. ProtoPage, PROTOPAGE.com. And what ProtoPage is, it's an aggregator. So you can grab off most sources something called an RSS feed. I know I'm probably talking Greek to some of you, but almost every website built into it has something called RSS, which stands for many things, but one of the things they call it is real simple syndication. So if you go to something like ProtoPage, and there's a lot of them out there, and you basically say, okay, I want to add this feed so I can look at it. You go to the website, you click on the address, then you say, grab the RSS feed, you plug that into the feed reader, and it will find the feed. And so then every morning when I get up, I'm looking at my news feed. I have different feeds for different purposes, but I have I have a news feed. I have one for Social Security disability. I have one for, I still have one for bankruptcy. I used to do a lot of bankruptcy. I don't do it anymore. I still keep it there. I've got one for workers' comp because I do some marketing work for my wife's practice. I've got one for photography because I'm into photography. I've got one for tennis because I'm into tennis. I've got one for AI. So basically, I find news sources or blogs or whatever it may be, could be video sources for that matter. And I get the feeds. And so for each tab on my protopage screen, I'll have 15 or 20 sources. So when I get up and in the morning, I kind of scan through all those different sources, and so I can see. So that's why I said I've got, some that are more left-leaning, some that are more right-leaning, some that are more in the middle, and I look at all of them. And it's a good way to kind of get a sense of what the reality is, because you just can't believe anything you read. And now you can't believe pictures or videos either, which is really kind of weird. But in fact, I'll make this admission, is if you look at my recent blog post at ssdanswers.com, the photos that you see there are not photos. They are made by an AI program called Midjourney, where I'll say I need a 45-year-old male in a construction worker looking dejected after hurting his knee following a fall from a ladder, and it'll give you a picture like that. Used to be I would go to these stock art websites, and you could buy an image. You do a search for an image. You could buy an image. It might be $1, $2, $5, depending on the quality of the image, and you pop it into your blog to give it a little bit of a picture. Now you've got all these AI tools that will generate an image for you. So it just with that. But the problem is, you see these fake videos. In fact, there was one here in Georgia where Senator Ossoff, who's one of our senators, they did a fake video of him basically saying something he never said, talking about, I think in this case it was about the shutdown. He's something to the effect of, I don't care if people lose their food stamp benefits, principles more. He never said that, never said it. Whether you like him or don't like him, he never said it. And I think it's really dangerous to our society when, people are using fake videos, and they can be really convincing now to say that somebody said something they didn't say. I mean, I look sometimes on Twitter, and it's a cesspool. I mean, people just repeating the most vile conspiracy theories and spewing this hatred, but it's out there, and they can create a picture to support it. And it's just, and a picture is worth 1,000 words. So I would just tell everybody, be real suspicious of everything you read or hear, because just because it's in print or online doesn't make it true. And, it's a real issue. Okay. I've had this happen a few times, really frustrating. ET beats Alien. After I got my approval from the judge, the appeals council on its own, decided to review the case, and funds are being frozen. This happens to me 2-3 times a year. The appeals council, I think some of the time it's a random thing. Others it may be based on the underlying medical problem, or maybe based on your age. For whatever reason, they're going to look at it. Now, I've been fortunate. I don't think I was ever any time at all that the appeals council reversed a case or sent it back for another hearing. It's always just affirmed what the hearing judge did. But it could happen theoretically. So hopefully it won't happen to you, but it could happen. But this is just kind of a check on the judges. Realize that the Social Security judges are fairly independent actors, in the sense that, they're appointed. It takes a lot as federal employees to get rid of them. And, but they're graded. I mean, they're graded on how many cases are appealed and successfully appealed, and on their percentage of approval, denials, things like that. They typically, the ones that approve more fall under more scrutiny than the ones that approve less, which is a troublesome concept, but it's true. But I think that the appeals council in some situations may pull decisions from certain judges, or they may again be random, or it may be based on the underlying medical problem, or it could be, any number of things. I suspect that we're going to see AI being used, artificial intelligence, where it may review the medical records, and if it sees conflict, it may trigger a review by the appeals council. Now, obviously, Social Security knows, the appeals council knows that you're going to be awful upset if you get a favorable decision from a judge and then it gets reversed by the appeals council. So I don't think they do it a lot. I think it would take a really lot for them to do that. But, there have been judges um, that have approved cases. There are judges, not so much anymore, but there were judges that were approving 90%, 95% of cases. And that was worrisome to Social Security. There's a video clip. I think I've got it on my blog at some place there. This is going back a long, long time, and I've probably told the story before. But South Carolina representative, he's now something else. I don't know what he is now. Trey Gowdy, got him Trey Gowdy, and he was a representative, former prosecutor, very aggressive prosecutor, and he was questioning Social Security judges with really high approval rates. And there was one judge he was questioning that I had been in front of. And this judge, really nice guy, but he approved 99% of claims. And my experience with him was I literally walked into the hearing room and he starts talking to me about where can I get a good sandwich. I mean, we probably had a 20-minute conversation about restaurants nearby. He was not from Atlanta. He was visiting. So he was a visiting judge there for like 2 weeks. And so he wanted to know where he could get a good sandwich. And so we were having discussions about delis for about 20, 25 minutes. And the client's sitting there. And then finally, after about 25 minutes, and I'm like, he wants to talk about delis. He's the judge. I'll talk about delis with him. I mean, I know a good deli when I taste one. And Atlanta, by the way, does not have very good delis. So if you're coming to Atlanta, don't come for the delis. But that's a whole different story. Anyway, this judge, after about 25 minutes, looks at me and says, I guess we probably need to look at your client's case. I'm like, okay. He's like, he looks at the client, he goes, Miss So-and-so, you're having a hard time working, aren't you? Yeah, you've got a lot of pain in your back and your wrist and your elbows and your neck, don't you? Yep. You'd probably miss 2 or 3 days of work a month, wouldn't you? Yep. All right, counsel, I've heard enough. I'm going to approve your claim. And that was literally the hearing. And, whether I don't remember if my client, if I remember correctly, her case was marginal. It wasn't a great case. It was decent. I mean, it was good enough that I took it. It was not certainly was not a slam dunk case. And it certainly deserved more of a review than that. My client was happy, obviously. I was happy that, we got a win and it generated a fee for me. But, in retrospect, that's not appropriate. Judges shouldn't be basing decisions, obligating the federal government taxpayers for tens of thousands of dollars by asking 3 leading questions. So anyway, this particular judge was being grilled by Trey Gowdy, and he had no answer for him. I mean, Gowdy would so you're telling me that I'm looking here and I see that you've heard in the last calendar year 150 cases and you approved 99%. Well, yes. I mean, I only approve cases where the person's disabled. So you're telling me that 99% of the people, that you saw, roughly 147 of 150 were approved, whereas your colleagues are approving, about 46%. But you're that much smarter than they are. Yeah, he just made him look like a complete idiot. The judge eventually resigned or retired or moved on. But the point here is that the appeals council is very concerned about that because Congress writes the checks, and there is a narrative in Congress that many people on disability are gaming the system, and so Social Security has to show that they're checking themselves, that they're policing themselves, and that's one way they do it. Now, it's a very long answer to a very short question, but the reason the appeals council doing that is to make sure that the decision by the judge is appropriate. Okay, Emiliano, does having an electrical nerve stimulator for herniated disc neuropathy? Yes, because those are minimally invasive, but they are, they're significant enough where a doctor is not going to do those things without a reason. Many times, um, you know, they will go to these sort of minimally invasive treatments like nerve stimulation, um, things like that, to where you're not really a surgical candidate or surgery has already been tried and not worked. So, depending on where you're at in terms of your journey for treatment, this is either part of the conservative non-surgical treatment leading up to possible surgery, or they've already decided surgery is not appropriate for you, or you don't want to have surgery. And so these are some non-surgical treatments that can apply. But yes, it is, doctors are not going to do these type of treatments for herniated disc and neuropathy unless there's something that's there to treat. And so obviously you have symptoms, neuropathy, pain. And so what you would want to prove is that the severity of it is significant enough to keep you from working. Okay. We'll consider with Emiliano. If you travel internationally while you're pending for recon, will that negatively affect your case if they become aware of it? I would say maybe, because you'll be many judges will ask, have you traveled any place? And if you're traveling internationally, if you're going on hikes, in you know someplace in France or in South America, or you're climbing mountains, yeah, that's a problem. That is a problem. If you're simply going there, I had clients that have, they went international, went to England or France because they had family there. Somebody was getting married, somebody passed away. My client testified that, basically it took 2 or 3 days to recover from the trip. They basically stayed inside except for the funeral or the wedding or whatever. So it kind of depends on what you do, but I think you need to be prepared to explain what you did physically, mentally, all those type of things, because going on a trip internationally is not entirely consistent with being disabled. Now, assuming you went someplace because you had family there, it's not unreasonable to visit your mom, or your siblings or other relatives or friends. But anybody who's traveled any place, locally or internationally, traveling is a pain. I mean, you're standing in line at the security. You've got to sit on a plane. You can't really move. So yeah, it's not entirely consistent with a person being disabled. So you would have, I think you could certainly say, I did this one time. My mom was sick. I had to go see her, or, I had to go to this wedding. If you do that and you testify that, it took you probably 2 to 3 weeks to recover, but you did it one time, I don't think that's going to really hurt you. But if you have every 3 months you're taking a trip to, Peru or something, I think that's more of a problem. So I think you just needs to be, it really depends on the context of what you're doing. But yeah, and then you can assume that their doctor's reports will mention you traveled internationally, so they probably will find out. But it's not inherently going to cause you to get denied, but it's going to be a question that you're going to be asked, and you need to be prepared to answer how you managed to do it given your underlying medical problems. Patty Brown. I was denied for diabetes, didn't look at strokes and kidney medical records. I'm appealing it. Yeah, and I mentioned earlier, when you get your denial notice, you want to read it carefully. You would be surprised how often they will deny the case on one medical condition and they couldn't get the records for the other two. They just said, we couldn't get the records, so we're not considering it. That happens a lot. Or the strokes, and this happens again very frequently. You may have had a stroke 3 or 4 years ago, and Social Security generally gets the records from about a year prior to your hearing. So that record may not be there. That would be something you'd want to submit directly, to show you had a stroke and you're still having problems with it. So yeah, they don't always look at all the records. A lot of times they don't have them, and they're so busy they don't have time to try to track them down. So yeah, that's another reason that an attorney can be of help to you, just tracking and making sure that they consider all the records there. Yeah, no, I don't think, Afsana, you're giving anybody negative vibes. I mean, I think that we all realize that, Social Security will, they pull the rug out from underneath you. That, they may tell you you're being considered for non-medical review. Logically, you'd think, well, it means they've approved me. It hasn't. I need to get more information about that so I can talk intelligently to everybody about that, which I will. But it's just the reality is that, they're going to deny cases when they want to deny cases. And it's unfortunate that that it looks like you're about to get approved and then they don't. But again, think about this, the person who had an approval by a judge and the appeals council says, well, hold on a second. We're going to take another look at that. Even worse. Proper Dame. Had a mental CE and the ALJ disagreed with the report and I was denied. How is that possible? It's possible because judges have a lot of leeway in deciding what medical records they're going to rely upon to approve or deny your case. And I think that's probably what happened here is the judge, looked at the medical record, the consultative report, which said you've got significant mental health problems. And the judge is like, nothing else in the record suggests that. I'm not going to give this much weight and we're going to deny it. So they can do that. And I've seen that happen. I've had a couple of really, really strong consultative reports in cases in the last few months. And I had to really work hard to get a judge to say, my argument is this is your own doctor saying this. But the response was, well, nothing else in the record suggests this. So, how is it that this the same argument I would make, how is this doctor who's only saw the person for an hour able to reach a conclusion that treating doctors saw this person for years and didn't keep coming to the same conclusion? Ugh. No tennis, and I just walked the dog for 4 miles, so I'm yawning a little bit here. Also, I got up really, I don't know how, if any of y'all have had this, but, since daylight savings time ended, I've been waking up earlier, and you think by now I would have kind of adjusted, but I really haven't. Some reason, sometimes I'll just pop up early, and if I'm up, I might as well try to get some work done, before things get crazy. So that's what I did. So I was up kind of early this morning. Elizabeth says, for a CDR short form, if I answer the conditions the same, the doctor and I have not discussed work. Will that trigger the long form? No. I think the less you say on the short form, the better. If you just answer no to everything, I don't think a human being reads it. I think it's just all electronic, and basically they just typically will just say, okay, benefits continue. That's my understanding, at least. What if a 60-year-old in SSDI gets a CDR and SSDI takes it away? Will that person be stuck for the rest of their retirement income they would have received if they had never been an SSDI? Well, you have to apply for early retirement. So you don't get it at 60. You get it at 62. So if, let's say, you were an SSDI, you get a CDR, the CDR, finds that you're terminated, you appeal it, you lose. You have to then apply for early retirement. It doesn't happen automatically. So you could theoretically wait until 66 or 70 and just not have any money coming in for 5 or 6 years. But unless you apply for early retirement, it is not automatically going to come about. KU Thunder. Wonder where you were. Good evening. Hope you're all having a good Thanksgiving. Well, hopefully next week we'll have a good Thanksgiving. It's like looking forward to that. Not a big turkey eater. I don't know if you guys are the same way, but I've never been a big turkey eater. I just find it a little gamey and kind of dry. Just not my thing. But a lot of people really like it. So I'll either have chicken or sometimes fish. This year we're going to a friend of mine's house. He just moved into a nice house, so he's having a bunch of people over, so we'll see. And we're going to bring my daughter is a pescatarian, as is my wife for that matter. So I think they're going to make fish. So I'll make a decision at game time whether I'm going to eat fish or turkey or something else. So we shall see. But not a turkey fan, just never been. There you go. I've heard that one before. And this is a statement, that there's a difference between knowledge and wisdom. And knowledge would be knowing that a tomato is a fruit, but wisdom would be not putting it in fruit salad. Very true. Very true. And I've run across a lot of people who are very book smart, but have no common sense, and same kind of concept. Patty, yes, I'll be 61 next month. I'm getting ready to file for SSD. How does the decision take? I don't see, the only difference that I see is that, I'm getting more early approvals on people over 60 because there's so many different arguments to use. You got the grid rules. You've got a PALMS regulation that talks about transferability of skills and really, limits the argument that Social Security can use to ask for to claim transferability of skills. So you have a lot more in your favor. Plus, there's a bias in the system. Judges realize that people over 60 are going to have a really hard time finding new work. So I think bottom line is that you're probably, there's a better chance than you'd have at 50. You get approved early, but there's nothing in the system that says you automatically get sped up, as it were. Dimple Bellamy. Dimple, how are you doing? Do you think someone who's been doing direct sales, makeup, cooking, or consumables a couple of times a month will cause an issue? No, I don't think so. Again, that was my wife telling me to put the clothes in the dryer. So see, maybe an attorney, but I'm just got to do what the wife says, no matter whatever accomplishments I've had. The wife says, put the clothes in the dryer. Got to put the clothes in the dryer. Okay. Anyway, back to Dimple Bellamy. Someone who's been in direct sales. I think if you're making, a couple $100 a month, that's not an issue. Again, what they're concerned about would be somebody who is doing something full time, 8 hours a day. They're making, $1,600 a month on a regular basis. If it's at a really minimal level, just to keep your mind occupied, I've never had that be a real issue. I think judges recognize that people want to do something. And, if you can do, a little bit, a couple days a week, and again, they may ask you, are you doing makeup? Are you sitting at a table and with somebody, and you're doing whatever you do to apply makeup, and you're doing it for 3 hours at a time? Yeah, that's, that consistent with a person with severe back pain? No. If you're cooking, for 4 or 5 hours and you're on your feet and you're lifting pans, I just think you have to be able to explain it. And again, if you have an attorney, you can come up with a way to explain what you're doing and really show that it's just more on the hobby end of things as opposed to really work. I think this is, like you said, a hobby income on a very small scale. That's exactly right. Am I accepting AC or federal appeals? Robin, generally, I will refer those out. I'm so busy with hearings. I do appeals counsel work. I do file briefs. Okay, my phone, for some reason, when I get a text sends it to me twice. So it's same clothes, same dryer there. But anyway, Robin, do I accept federal court AC appeals? I do. I've done AC appeals. I don't do federal court work at this point anymore, just because it's time-wise. So if you need a recommendation, I can give you a couple of names. If you email me, ssdanswers123@gmail, I'll give you a couple of names of people who do really good work with that. And I know people who do it, and I work with them a good bit. Osterhout is one, and Brian Konoski is another one. Okay. All right. So Canova got an approval at Recon, but they changed the onset date. This is an ongoing issue. I see this a lot. You appealed it, and you got to really look at that to determine how much they shortchanged you. Now you request a hearing. So usually get a hearing after a Recon, you're appealing a Recon decision. You get a hearing in 6 to 8 months. That's pretty typical. My medical records for the injury are old, also have new serious medical limitations. Yeah, I think if you've got old records, you may need to get them in yourself. And obviously the new stuff, you want to pay attention to your onset date though, because I've had people sometimes, let's say they had an onset date 2023, then in February of 25 they underwent 5-level fusion. you know you don't want the judge to say, well, I'm going to find you disabled as of February of 25, even though you were disabled back in 23. You'll get no past due benefits. So you have to kind of really balance how you position that and make that argument there. But yeah, you want to submit everything that is relevant. But again, you can phrase it, position it in different ways. All right, Patty Brown. I got diabetes in 15, almost went blind. 24, got COVID, lost half my left kidney. 25, 2 strokes. I was denied. Why would you be denied? I mean, were you denied because of lack of credits? I wonder, Patty. I mean, I can't imagine you could get denied on all that. I mean, again, you haven't really discussed the symptoms, but I would think with all these things going on, that seems like a pretty strong case. I'm going to hazard a guess. Maybe you don't have enough credits. I don't know. That could be the issue. I don't know. So when did you last work, and what is the what is your date last insured? And unfortunately, once you apply, you can't get a My Social Security statement. So you have to kind of. But if you look at your earnings, over the last 10 years, and maybe you call Social Security and say, "What's my date last insured?" Because that may be the problem. You have to prove your disability began before 2018 or something like that. And that would be obviously before the COVID and the strokes and all that kind of stuff. That could be the issue. All right. Doug asked, don't qualify. All right. I think this is a question Doug had asked a while back, and he was asking, he had significant medical issues. I can't find it off the top of my head here. But he's like, why would they deny me? And I'm like, is it SSI? You have SSI is means tested. So any household income, any assets you've got beyond a certain limited amount count against you and would offset your SSI. So that's a concern. That is a concern. It's hard to qualify for SSI if you're married or if you have any kind of assets at all. Hackasad, does SSA, like the initial application stage check for SSA qualifications, could be. And again, some people, this is a good point that you bring up. Some people apply for SSDI and SSI at the same time. SSI, they look at it and say, you don't qualify for SSI. They send you a notice, you don't qualify for SSI. If you don't read it carefully, they're not saying you don't qualify for SSDI. They're saying you don't qualify for SSI. So, in terms of your underlying case, the SSI office is different than SSDI. Maybe what's going on here is the SSI office kind of independently made a decision. You don't qualify non-medically for SSI. Meanwhile, the adjudicator is looking at this in terms of the merits. You don't qualify medically. Like I said, I'm going to find out from my former adjudicator guest and see if she'll answer that question for me, because I think it's a very good, very, very good question there. Okay, so this Doug has had lymphedema. At work, haven't worked in many years because of the lymphedema. Yeah, this is a problem, and you could pursue SSI, but it's not a lot of money, and you can't really exceed the asset limitations. Unfortunately, Jeff has 2 herniated discs. Need a fusion because it's impinging on the spinal cord. Maybe, again, the listings for musculoskeletal are really, really tough. They make it really hard to win. So, you could certainly make a listing argument. You could also make a functional capacity argument. You might be able to make a grid rule argument depending on your age. I always tell people, if you meet a listing, 35% of applicants, get approved early because they either have a terminal illness or they clearly meet a listing. It's hard to meet a listing. And back pain being the number one reason people file for disability, it's even harder with back pain. So I don't want to say, without looking at medical records, I can't really say. It's hard. It's really hard to meet the listing. On me, what are the chances of approval for moderate to severe formal stenosis along with congestive heart failure, ejection fraction of 47, 53 years old? All right, so let me unpack this. It helps that you're 53. It'd be better if you're 55, but it helps that you're 53. You could basically win under a grid rule, even if you could do light work, you could be found disabled. Severe stenosis, helpful. That's a significant problem, and your symptoms that might limit you that would prevent you from performing light work, I think would be consistent with severe formal stenosis. Congestive heart failure, ejection fraction. 47 is low. It's not like 25. I think normal is like 50 something, 55. So you've got, I'd say moderate level of congestive heart failure. But again, is it enough with the back issue to take you out of the light work level? I'm thinking it probably would be at 53, and I think you would probably have a pretty good grid rule argument. Gridrules.net is the website for that. But I would think that, yeah, that sounds pretty good to me. Lisa, hey. Yes, Lisa from close to Disneyland. My pleasure. Good to see you, Lisa. Thanks for tuning in. I appreciate it very much. Yes. Disneyland. I was in Disney. I'm on the East Coast, and so I've been to Disney World a few times. My daughter played basketball, and they had the AAU championships down there. So we went for several years, went in a row. But when I was a little kid, I'm probably 8 or 9 years old, my mother's brother, my uncle, lived in Los Angeles. And so we'd go out there. And so I went to Disneyland when I was 8 or 9 years old. I've got home movies of me in Disneyland. So I remember it. It's kind of been a long time, but it's what's the ultimate happy place? What they say, right? Actually, I saw where Mickey Mouse turned, was it 98? I think it was. I can't remember how. It's been a long time. I think 98 years old. The first Mickey Mouse comic book came out. So Disney's been around for a long time. Will Social Security accept workers' comp doctors' opinions of injuries? They will consider it. Again, when you say accept it, yeah, they will consider any medical evidence. How much weight they give it is a different story. Now, generally speaking, workers' comp doctors are very conservative. So if they find a significant problem, I think you can make an argument that suggests that the problem is really probably even worse than what the doctor says. Now, I would also add that if you're on workers' comp now, that's a problem because you can't collect both at the same time. Usually workers' comp offsets SSDI, SSI, so you wouldn't see any money until the workers' comp case settles. But are workers' comp doctors' opinions considered for good or for bad? Yes, they're medical reports and they're very relevant. Robin, the ALJ cherry-picked my medical record for specific items on mental health to show improvement, discounting APNP, LPC diagnosis and treatment plans inconsistent with the rest of the treatment. Okay, and that might be very good grounds for appeal. I think when a judge, misrepresents what the record says, that could very well be grounds for appeal. And that would be, again, something that a person who does appeals work all day long would be able to spot probably better than me. So again, if you email me, I'm more than happy to send it along, give you a couple of names. All right. So yes, if you want a case evaluation, this is where you would go. I've got the, and by the way, if you find this useful, here's a place you can offer a review. Reviews are much appreciated. I've had that on the crawl for a while. Very much helps my web presence. So thank you. I would appreciate it very much. So Robin, you're asking about the appeals. Yeah, judges can do whatever they want, and whether they can get away with it's a different story. Whether the appeals council would say, not so fast. We got to, we need to look at the medical record a little more closely, and we see that the underlying record suggests something more than what the judge says in his decision. Always killing it. I had a CE on October 28th, but DDS hasn't received it. What do you think the time limit 14 months at recon? Yeah, that's way too long. Way too long. The CE on October 28th, it should be received by now. We're at November 19th. Although again, with the shutdown and so forth, things got slowed down. I would keep following up on that because that really should be in the record. But you're getting to the point where it's way too long, way too long. Oh, you're watching me on a laptop and it shows vertical. That makes no sense. If you go to YouTube or I'm on Facebook, on YouTube, you should see it vertically. But that's a good question. I don't know why anybody else seeing on a laptop seeing this vertically? I don't know why you would, because I set it up where it would be both. But who knows? Who knows? Interesting. I'm just going to look real quick here and see if there's anything I can see. It's on both. I set up to show both. So for some reason, your laptop is defaulting to vertical. It should be horizontal on a laptop. Have I checked out OBS Studio? I have, and I have OBS. I've actually got something called a YOLO box, which is another streaming device that I did for a while, and I may go back to it. I'm going to test it again. But StreamYard's so easy. OBS it's not that user friendly. I have used it before. I've never streamed from it, but StreamYard I've used it to generate videos. I've never used it for streaming, but StreamYard's so easy. You just literally identify your where your streams, where you want to stream to. You basically just associate your YouTube channel, your Facebook page, or whatever Instagram page with it, and just click start. The only thing I've found about StreamYard is sometimes there's a little bit of a delay between my mouth moving and you hearing my voice. Whereas with the YOLO box, I can make an adjustment for that. So we're going to look at that. I mean, I'm starting to do more, taking some of these stream recordings and making smaller videos out of them. So if that's becoming more of a problem, I may try the YOLO box again. It was not inexpensive. It was fairly pricey. That was before I knew about StreamYard. But what it does, it's like this kind of a really cool device. I'd show you, but it's down in my cabinet over here. You can connect like any number of sources to it and stream to it. So you could have, somebody on a telephone. You could have, a lot of different guests. There's a lot of different ways to use it. It's really designed for this particular physical product is designed for people that are in the field that want to stream an event, a game, things like that. So it's really it's overkill for what I'm using it for. But, OBS is out there. There's a lot of them out there. Again, StreamYard to me is just ease of use. And I'm busy enough with hearings that even though I like to play around with some of these technical things, it's just I don't have time. I really don't have time for it. But I've got OBS. I've got it on my computer, and I have used it before. Actually, I was using it to create vertical videos for Instagram, and I still do for that purpose. Sometimes I use my phone. Sometimes I use OBS to do it. But again, not real user friendly. Now, I haven't really studied it, but OBS stands for Open Broadcast Studio, by the way, if anybody's concerned. Well, asked about it's free. It's open source, but it's a little hard to use. Reality is be the best person you can be. Agreed. Christy, how is AI going to impact the ALJ? I think that's a really interesting question. I could spend a lot of time talking about it. I was listening to I'm in an AI mastermind group with an attorney who's real technical, done this for years, Ernie Svensson. Ernie, the attorney, had a blog for many years. And we meet a couple times a week with a group talking about AI. And he did an interesting podcast where he was describing a speech that was given at CleoCon, which is Clio is a case management program a lot of law firms use. I use Clio for part of what I do. I use it for the lead intake, and I use my case for case management. But regardless, he went to CleoCon, and there was a guy, I forget the guy's name, but he gave a speech and basically said, that in the next 10 to 15 years, everything is going to change. I mean, basically that, AI is going to get so smart that, if you have a medical issue, that you plug in your information and it will, based on accumulated knowledge, it will give you an answer. Yes, you are meet Social Security's definition of disability. So in other words, judges, adjudicators, lawyers may not be needed. I mean, or rarely needed. It may be a situation where, like self-driving cars, where, the standard for disability is becoming somewhat objective. This is the evidence you need to win. And, it will be able to have built into it. It can tell if it's, manufactured evidence, fake evidence, and it becomes so sophisticated that it takes the brain power of judges and it will give a decision. And Social Security, if they can get the courts to agree to it, will just make decisions based on that. And so, rather than go through this whole, a mishmash of applying and reconsideration appeals and hearings and appeals to hearings and appeals council and district court, it may be a process that happens very, very quickly, and that it's, the accuracy is going to be, 98%, and then the hearings will be, there'll be a very few number of judges and very few attorneys, and hearings will be very, very unique situations. That's the prediction. And this is just this speech was not about Social Security, but about every area of law that, people don't, as the speakers said, people don't, they may like their lawyer, but they don't want to pay a lawyer to do a divorce or an estate plan or a disability case or injury case. It's a necessity, cost of doing business. But if AI can do all that stuff, they want the result. And, I think there is probably some truth to that. So, the thought this gentleman had was that it'll be 10 to 15 years before AI reaches that point where it is reliable enough to sort of take over from human beings. We shall see. But I think that, what Linda said, my adjudicator guest from a few weeks ago, she said that there is an AI program that's available to Social Security. Right now, it has a lot of restrictions on its use. It's not very robust, and that they don't use it that much, but it will become more and more. I mean, you think about it, my AI right now is in my brain. Like I look at a lead, okay, somebody sends me a case evaluation, I can usually tell with pretty good amount of accuracy whether it's a viable case or not. A 30-year-old with a broken thumb is not going to win. I mean, 99%, unless you got a crazy judge. A 57-year-old with 3-level fusion, failed back syndrome, and congestive heart failure and brittle diabetes with amputated, toes on the foot, that is a winning case. So, right, could I put that into an AI model? Probably, but right now it's still too broad. I mean, the obvious cases are ones that you could use, but yeah, there's going to come a point where judges and Social Security will use it more and more to make decisions about cases, or maybe even there'll come a system where they'll, offer a claimant a probability score, that you put your information in there, and based on, the not giving you a decision, but based on the evidence, the odds are, 87% that you're going to get approved, or the odds are 37% you're going to get approved. And maybe it would tell you why. You may or may not. I don't know. I'm just throwing that out there. But yes, AI is not going away. It's going to change fundamentally what lawyers do. I mean, I'll probably be retired at that point, quite frankly. But anybody in law school, I have a good friend of mine whose daughter's in law school, second year in law school, and I'm going to send him this podcast episode. Like, you need to have her listen to this, because learning how to work with AI will become more of what lawyers do. Is figuring out what information you need to give AI a clear picture. That may be what lawyers do. But what this gentleman said, I'll get off my soapbox in a second here, is that there's a certain percentage of people in the law who don't adapt it, and they're going to get left behind. But it's going to fundamentally change what we do. And he talked about, at the beginning of this speech, they showed a video of some lawyer, somebody, it was kind of tongue in cheek, but it was real video of somebody saying, well, fax machine, who would ever use a fax machine? Who would who would ever use cloud computing? Some of the things that we take for granted, are just, they're science fiction. If you went back, I've been practicing law for 35 something years. And when I started out, I had a computer with 2 floppy disks, no networking, no internet, no web, no AI, none of that stuff. And, now this is what I do on a day-to-day. Like I said, I'm talking to all of you all over the country from my basement, and it's clear, and it's something that can be saved, and you can refer back to it. You could download it and put it into an AI engine, get a transcript. I mean, it's science fiction. We all are living it, but we're at the beginning part, and in 5, 10, 15 years, consider what we're doing now. This is like, looking at fax machines. It's going to be, computing power will be increased by 1,000,000 times. So, answer your question, Christy, is yes. Okay. All right. I'm running out of time here, so let's kind of zoom through a few of these. Remand, Title 16, no evidence title. Okay, so this is a bigger problem in that if you didn't apply for disability, they're only going to consider SSI, Title 16. So you need to look at the evidence to see, did you actually apply for disability? And that's what the judge is going to have to do. So that's tough. But I appreciate the $4.99, absolutely the tip. Appreciate it. Goes to lunch for Jake Ginsberg, my son, and myself. Much appreciated. Thank you very much. But yeah, that's going to be a matter of, can you prove that you gave Social Security and SSDI an application? Part of my claim is an old injury got worse, lumbar occlusion fusion, have an MRI and CT on film, not digital. I think that you might need to go to an MRI clinic and see if they can generate. First of all, most judges prefer to deal with written reports, not look at films. They're not really qualified to look at films. So I think what you probably would be better off doing is taking the film to a radiologist, have him or her read the film and generate a report. That's how you would submit them. I don't think you really want to submit to actual films. I mean, I've seen that done. I've seen, pictures of, I saw one the other day. It was a client of mine who had a, colonoscopy. And so they showed pictures of the colonoscopy, that there was a polyp or whatever. But judges aren't medical doctors. They're not going to do much with that. You need a report, I think. Okay. All right. Donnie Doomsday, spinal stenosis, nerve root impingement, IBS, 9 times a day. Good case. Looks like a good case to me. But you're 35. That's going to be what you got to get past. Good case, but you're 35. Okay. Got time for a couple of more here. When changes are made to application for SSD and SSI is responsible Congress. I think that generally it's going to be done by Social Security, the administration. I think that the applications, I don't think Congress gets involved in making applications. They're involved in the law, but the applications have to reflect what the law requires. So it's sort of both, but generally tweaks to the forms is done by Social Security. Have I used talking about borderline? I think you're talking about borderline age situation. Yes. Let me just sure. I mean, that's what you're talking about. Because I look at the rulings. Kane. Let's see. Kane versus. Okay. You know what? Let me age. It's talking about age, yes, and I think it's the borderline. Yeah, I look at what I'm looking at generally is there's a POMS regulation. POMS stands for Program Operation Manual, and the POMS regulation. Let me see if I've got it here. Well, there's a POMS regulation on age, and I've got that actually bookmarked here because I have used that recently. I used it the other day, as a matter of fact. All right, I can't find it off the top of my head. I can't find it, but it's a just look up POMS regulation borderline age, and it explains how that works. And basically, it codifies Kane versus Heckler is really what it's doing. Okay. But I used the borderline age situation. I've used it several times in the last month, actually. So yes. Approved for disability but denied 2 years back pay. Is that common? More and more it is common. What they're doing is they're changing the onset date to cut you out of past due benefits. You can appeal that, but you got to make a decision. How much money is at stake? Is it worth appealing? All right, Muley's talking about the same thing. Approved at onset at 55, going to the ALJ, should get a medical source statement. Yeah, if you can get one, yeah, I think that would be, medical source statements are always helpful. Always helpful. All right, let me get a couple of more here, and we're gonna Alicia, hey, one of my old clients, we won. In the case where SSDI reassessing disability, was there any grandfather rules were all in danger of being once approved? Yeah, I mean, I think that, again, they look at your situation, and everybody's in danger. The presumption is they made a decision, they find you disabled. If you're 30 years old, you've got to be more concerned than if you're 50 years old or 45 years old. The older you are, the better it's going to be. So everybody's in danger. They could come in and review everybody, but they don't have the personnel to do it. So I think in your case, I would not be worried, I don't think. Okay. Let's, okay. All right. So RD says you have set up, that's right. I did set up 2 views. Okay. That is exactly what I did. Okay. My claim was at stage 4, waiting for a doctor. Never got to see one. Just denied without seeing anyone reconsideration. Recons figure a 7 to 12 months, depending on where you live. Okay. So Robin used AI to analyze your case, give me errors. Yeah, I mean, you got to be careful about that. I use Notebook LM, which is a RAG, or closed system, and it does not go on the internet. If you do use AI, I would tell everybody, get the paid version, the $20 a month version. You can tell it not to train on your data. That way your data is relatively safe. Again, I like the Notebook LM because it's closed and it's not going anywhere. But, is there true data privacy anyplace? On the other hand, as somebody pointed out in this podcast I was listening to, you could have an office, somebody could break into your office and steal files. So, is there 100% confidentiality of anything anymore? No. I think you got to take reasonable precautions, but don't use free AI tools. So anyway, all right. I think that we are at 2 hours. I appreciate it very much. Next week will be obviously the day before Thanksgiving. I plan to be here, so I'll get notice out to everybody. And again, I will see what I can find out about the this question that we've been sort of talking about, that they get the non-medical approval or non-medical is being considered, and then they get the denial. And what's the story with that? I'll see what I can find out about that. So anyway, hope everybody has a great weekend. Stay warm. I think it's going to be another polar vortex coming in, and I will see you all next week. Thanks a lot.